When we talked about the Harvey Weinstein case, they brought in other testimony from other women who had had similar interactions, almost like as a character witness kind of thing.
So establishing a pattern.
And there was a total of 3 women. And because those 3 women were allowed to testify, that case ended up getting overturned. That trial was essentially made invalid because of that. So there was some confusion about that. And I actually had a lawyer that wrote in to explain to me why that is, but then also give me some interesting history on this as far as court goes. So she says the basic rule is evidence of the defendant's character/propensity to commit crimes is inadmissible because we're concerned the jury will convict him because they think he's the kind of person who would do this, rather than really making a determination of whether he in fact did this.
Okay, that makes sense.
However, until the 1970s, most U.S. jurisdictions had the opposite rule for sex offense crimes. The defense could introduce evidence of the victim's sexual history for one of 2 purposes. Either 1, to prove consent, because if she's having a lot of sex, then she probably consented on this occasion too. Or 2, to show she's generally not credible because she is a woman of loose morals, so her testimony should be discounted.
Until the 1970s?
Yes, this was a specific evidence rule that only applied to victims in sex offense cases.
Oh, you know, freaking why that was put in the law?
Yeah.
So guys could get off from doing it.
In the 70s, most states and the federal government fixed this by passing new evidence rules that are known as rape shield laws that makes evidence of the victim's sexual past now inadmissible, except for very narrow purposes. But then some jurisdictions went even further, passing laws that affirmatively allowed character evidence against the defendant, specifically in sex offense cases only. California and the federal government both have these. New York does not, hence the Weinstein decision. So in other states, it could have been admissible because some states took it further and said, actually, yes, that is valid evidence.
Man, get with it, New York.